of an actual eviction, just because she's been there long enough that she's established residence, that at this point it's not a criminal offense of her being there. That's kind of a civil issue between you and her and between her and the landlord.
Okay, so what if there's like illegal activity going on at the place?
Then you can call and you can advise us of that when that's actively happening. If you have, details that can be backed and proven that it's happening. However, even if she's arrested from the house, she's still going to have the right to be there when she gets out of jail until she's been evicted.
Okay, so what about like my right to be there?
You have just as much right to be there as she does. As far as we're aware, you've established residency. If you've been living there, then you can stay there, but she has every right to be there too. And if you in any way like prevent her from being able to go back inside, or your landlord, then you guys could get in trouble for an illegal eviction. And she'd basically be told by the sheriff's office and she can get into the house however she wants to. And again, it would be handled civilly between the landlord and her, between you and her. But as far as like locking her out or kicking her out, you legally can't do that until she's been evicted.
Do you have the,
if she's unwilling to go.
Do you have the state statute where it says that?
Or it says what?
Everything you were just saying about like an illegal eviction and preventing someone from going back in the house.
Yeah, it's not written in the statute that you can't lock somebody out of their house. So if you're looking for something like that to be outlined in statute, it's not. It's just what the law says. You can't lock somebody out of their house.
Well, that's what I'm trying to figure out is where does the law say that?
Okay, so I'm telling you that this is the way it is. I don't know how to help you. Like I said, the process to get her out is through a legal eviction.
Yeah, I understand that.
If she has a right to the house, which she has been living there long enough to establish residence, which is 2 weeks, then you have to go through the process of evicting her to have her out of the house. Otherwise, it's considered a legal residence, and you cannot lock somebody out of their legal residence. Like that can be enforced as far as our concern. If she's locked out of her legal residence, and she can take any action that she would like to regain access to the house, and that isn't a crime because it again is her legal residence.
Okay, so if so say she was to lock me out of the house, then I could take any action to get back in, and there's no there's nothing illegal about that.
As long as you're not like threatening to harm her, as long as you're not doing anything. Now that's between you and her. However, civilly, your landlord could enforce whatever he wants to on either one of you guys. And if you were to damage the door, if you were to damage whatever, then he can come after you civilly in order to pay for the reparations of the damage.
Okay, so my landlord told me that since he's the owner of the property and I'm the legal tenant, that I have more rights than he does as far as evicting someone.
I think he's trying to get you to do something for him, in my opinion, but I can't give you civil advice.
Well, I'm just trying to understand like what the actual law is regarding all this, and like what is legal and what is not legal.
Okay, so as far as evictions, the entire tenant-landlord relationship, all of those tenants in common, all of those different definitions, that's all handled through the civil courts. So that's not anything that we act on. That's not anything that we can give advice on. We can just kind of point you in the direction of saying, hey, if you want somebody out of your house who has established residency, which in this case has happened, then you have to go through the legal eviction process. I don't know who has more rights, who has less rights. I know that your landlord has the right to remove her if that needs to happen, and that's why I'm trying to tell you that your landlord has the same abilities to remove her as you do. I'm just saying that if he's telling you that you have more of a right than he does, I just don't think that that's correct. But to be fair, I don't know entirely. So.
Okay, so where would I find all the legislature regarding all that?
Are you looking for, like, again, you're kind of asking for something to be written legally, but what you're probably going to have to do is you're going to have to go to the Larimer County Court's office. I assume it's in the clerk's office would be the process that you would go through to get a legal eviction. And then once you've attained a legal eviction through the courts, then you can have it served or posted however they tell you to. But as far as, like, I guess I'm a little bit confused by what you're asking as far as the legislature.
Like the law, like where it states all the legalities regarding the eviction process and what you can and can't do.
So if you're looking for that, then all I can tell you is that you should consult a lawyer. Because, again, all of this is handled through a civil court. None of it is within our jurisdiction. We don't have any training knowledge about any of that. We're just trained that, hey, if somebody has established residency, then we enforce that they have residency until they've been legally evicted. Because at that point, if you've been legally evicted, then if you return to the property, that's trespassing, and that is a criminal offense.
Okay.
Everything else that's documented outside of that, you're better off consulting like an attorney who specializes in that tenant-landlord relationship, or otherwise a civil attorney.
Okay, so how would I go about getting like a protection order?
If you wanted to apply for a protection order, then what you do is you go to the Larimer County Clerk's office. They have a process that allows you to apply for a protection order, and then you go before a judge, and the judge determines whether or not it will be granted and for how long. And whoever, obviously, the protection order is against has the right to go up and kind of like argue against it or whatever, but that's all handled through the county clerk's office.
Okay, so that's nothing involving you guys as well?
No.
Okay. So basically what you're saying is you don't know anything about what I can do, and you can't help me in any way?
Yes. Yes, I'm telling you that the relationship that you and your girlfriend have entered into with your landlord is a civil relationship, and all of the ways to handle that is going to be handled through civil court. None of that is determined through criminal law, and that's nothing that we can enforce again until either a protection order has been issued by the civil courts or an eviction has been issued by the civil courts.
Wait, so you guys only enforce criminal law, not civil?
Correct.
Interesting. I guess thank you for your time.
Okay, if you have any other questions, you can give us a holler.
I will do that. Do you have a phone number I can reach you at?
Yep, it's 970-416-1985.
Okay, and that's to the dispatch, or?
Correct.
Okay, well.
Do you have any other questions? Is there anything else I can help you with today, sir?
Anything else? I would have to say no.
Okay, perfect. Well, you take care. Have a good rest of your evening.
Good luck to you.